Hey everyone, welcome once again to Fitz in Law School. I'm Fitz, and today we're going to be talking about oral argument. So, first of all, let me give you some context about what oral argument is. So, every single law student throughout the entire country essentially goes through the exact same kind of education in their first year. And that also includes something called oral argument. And so a lot of different schools do it a lot of different ways, but it culminates in basically the exact same thing. So in courts, you have basically two levels of like what the lawyer does within the court. The first thing they do is they submit a written brief, and that's all their cases, that's all their arguments, that's depending on which side you're on. If you're the plaintiff, then that means that it's your complaint. That means it's the reasoning about here's what went wrong, here's the laws that they violated, here's the party that I'm suing, and here's the damages that I want, or the relief that I want. For the respondent, or not the respondent, but for the defendant, but also for the respondent once it gets into the appeals process, then that's when they essentially respond with a brief, usually a motion to dismiss, but also like your counter argument essentially to that. And then the second part of what a lawyer does in court is that's where you get into the oral argument kind of thing. And so like if you ever go on a SCOTUS blog and you hear the lawyer is talking to the Supreme Court, that's what that is. So that's oral argument for the case. So in the spirit of that, essentially what all first-year law students do is they go and they write a brief, and they have like an appellate brief, and it kind of works as kind of an appellate class as well. But for us anyway, what we did is we spent half of the first half of the semester essentially writing a responding brief to the case, and then the second half we started practicing oral argument. To sit before a panel of actual judges or actual lawyers, and we'd stand up there for about 15 minutes, and we'd go through kind of our spiel, and then we'd be peppered with questions. And the questions could be anything about the case, and so you really gotta know your facts and all that stuff. So what I wanted to do is I wanted to talk a little bit about my experience, and then a little bit more of like the general things. Let's see, which one should we do first? Let's do my experience first. So I was kind of in a unique position because my class, the entire 1L class was essentially divided into like, it was something like, I don't know, 15 or 20 different ones, and there were like 10 different cases, and so a lot of them had like repeats. But yeah, so essentially there were 10 different cases, and these cases were real cases, and they were all across California, and so the case that I was handling was a case called White versus Square Inc. And that's a pretty interesting case, but I'll give you a quick summary. So essentially a guy, Robert White, he went and he was a bankruptcy attorney, and he went and he visited the website for Square Inc. And so Square Inc., is the things where you can plug them into your phone and then swipe your card and all that stuff. So they're a financial transaction company. And in their terms of service, they list out, obviously the various things that you can and can't do with their service, and the repercussions for a violation of terms of service and the rights of the company. But then they also have a list of essentially what the customers of Square can and cannot do. And at the very end of that list, they said, we are not able, or you are not allowed to use our services for bankruptcy attorneys. So like processing payments for bankruptcy attorneys. And this was actually not in the record, and so you really couldn't talk about it. But essentially it was, why the hell would they do that? It's because of money. It's because of financial interest. They would, if they went and they processed those, then that would have to get tons more permits, and that would just be like expensive. But we couldn't really talk about that because nowhere was that in the record. So this bankruptcy attorney, he went and he sued Square for discrimination, occupational discrimination, which is a protected class, and he can in fact go and sue for that under a particular act called the Unruh Act, the Unruh Civil Rights Act in California, which matches a lot of other civil rights acts across the country. But the wrinkle is that he essentially went to the website. He saw that bankruptcy attorneys are not allowed, and so then he left the website and said, I've been discriminated against, so I'm suing you for discrimination. So the essentially the issue was a standing issue. It was whether or not that counts as discrimination. And so that's what it was about. So, so I was in the unique position because I was in a class that was dealing with that situation, and we had an odd number of students. So like I mentioned last week, I just decided to be the one to volunteer to go twice. So that was, and I don't regret it. That was super fun. We were lucky enough to go and actually argue in actual courtrooms before actual judges or actual lawyers, but in a superior court here in San Francisco. And so everyone went on different days. I went on Wednesday and Thursday. And that was the 2 days that my entire class were kind of spread out over. To start off, you walk up to the courthouse. You're dressed in a nice suit, which is always super fun. You have your, some people had their entire brief. Some people actually had a script. Others didn't. I personally don't really like a script. I just like knowing the facts and then just kind of having a little bit more of a conversation about it. But yeah, so you walk in, you get through security, and then you sit outside the court. And you wait, and you wait, and you wait, and you wait. And then all of a sudden your professor opens the door, and you walk in there, and you sit down. You sit down, and then in our case, it was the TA, essentially was the bailiff. And so they stood up, and they said, all rise, and, oh, yay, oh, yay, oh, yay, and, all that stuff. So it was a lot of stuff. But so I was the respondent, and so I was representing Square Inc. And so the format is essentially the petitioner stands up, and says, to start off, I'd like to reserve 2 minutes for rebuttal. That's the pretty standard practice, is that they have a total of 15 minutes, but the petitioner can rebut anything that the respondent says. They have the right. I don't have that right. And so I only get to go once. The petitioner has the choice, but the petitioner usually goes twice. 13 minutes on the first half, and then 2 minutes at the end. So essentially, the first time we had 3 judges, and they were really nice. They were really understanding. They were really friendly, and they asked some pretty interesting questions and stuff. But in my experience, it was about like 2 minutes of them just letting you talk, and then all of a sudden they start asking questions. And the questions are they usually are just essentially talking about, okay, let's like take what you're advocating out to the end of like what that would actually mean. Is this a good idea, or do you think this is impractical or something like that? So like for my situation, what it was they were talking about how important discrimination lawsuits are and how important it was to enforce them and all that stuff. And so they seem to be worried about setting the bar too high for someone who needs to achieve standing in a suit of discrimination. So primarily what I argued for was, I said that the case law across the state is really supporting an affirmative action against someone. And I had, these 4 cases, 2 of which kind of seem to go and support the petitioner, but I argue the opposite. I said, so the petitioner thinks this is actually supporting them, but it's not. It's actually supporting us. And so I just essentially said it's not about setting a higher bar for discrimination. It's about setting a clear bar. It's about establishing a clear rule. And I primarily used a case, Surrey versus True Beginnings LLC, in which this guy went and he went to a dating site, and he saw that there was discounted prices for women, and so he chose not to make an account, and he chose not to do anything. He just sued for discrimination based on gender discrimination, and the court in that case said you don't have standing under the Unruh Act because you didn't even try to create an account, and if you did, like, it wasn't terminated, like nothing happened to you. And so the Surrey case was like the big sort of slam dunk case for us. And for the other side, it was the Osborne case. That was the pretty good one. But in that case, essentially what it was a guy named Osborne, who was a guy with disabilities. He went to a hotel, and in that hotel, the hotel manager or whatever essentially saw that he had disabilities, like he had a service dog that was associated with his disabilities. And so the hotel said, yes, you can stay here. However, you have to pay an additional amount of money. Like it was something like $80 or something, or I don't know. It was a good amount of money. in order to pay for like a cleaning service because you have a service dog and because you have disabilities. And so he refused, and then he sued under the Unruh Act, and he did have standing. And so the situation with that was that the court held that was a act of discrimination against someone, even though you presented yourself to the business, but you didn't pay. Then that means that you can still have standing under the Unruh Act if you can demonstrate that it's an act of discrimination. But the little wrinkle that I said was essentially that the courts across California, they weren't pointing to payment as the bar for discrimination because it was payment. That wasn't my point. My point was that they were not saying that you have to pay or you have to not pay in order for there to be an act of discrimination. There just has to be an actual tangible action against you in order to count as discrimination. So it was, again, it's a very, very interesting exploration of how to argue these cases and all that stuff. And so I thought it was really, really fun. My partners, so it was just 1v1. And so, the partner on the other side, both of them did really, really well. And both of them presented a really, really interesting, argument. And so it was just super fun. And then the second night was a little bit more, interesting only because, so the first night I chose to really stick to my points and kind of talk about, like, I talked about the other side, but I didn't talk about what the other side said in their argument, like during the oral argument. And the judges that first night said, you should try and do that because that's always a good idea in oral argument. So the next night, remember, I had 15 minutes to go. And so the next night I said, hi, I'm Jeff Fitzpatrick, counsel for the Respondent Square Inc. And I said my little spiel, and I said, before I get into my first point, I'd like to address a thing that the petitioner came up with, and essentially talking exactly about, because I saw that she was primarily focusing on the Osborne case, and so I said, hey, I think that supports us, and so I went into addressing that point, and that line of questioning took up 14 minutes. And I made my points and all that stuff, but still, like, it is pretty amazing to see that, like, I didn't get to any more of my script whatsoever, or any more of like my bullet points 1, 2, 3. It was nothing but just answering questions, because I came out swinging. I came out offering a lot of evidence, but also a lot of kind of like strong opinions. I offered my own hypotheticals, and they kind of came back with other hypotheticals. It was really, really interesting. And beforehand, a couple of my classmates who went before me, they walked out of the courtroom and they're like, "Ooh, that's a hot bench." And that term hot bench is essentially they ask you a lot of questions versus a cold bench is they just sit there and just let you talk. And I would way prefer a hot bench because usually you go into an oral argument with about, you're talking for 15 minutes. And so you have about like 7 or 8 minutes worth of like material that you can just talk through. And then you also always have the policy in your back pocket, which is, no one really ever likes to hear a primary policy argument. They usually like to hear a legal argument. But if you run out of things to say, then you got to start talking about the policy. And so that's always something you can do. And the policy argument is essentially saying, think about the burden that this will present to like the legal community, and it'll inundate courts with frivolous lawsuits and all that kind of thing. The court system is always trying to avoid that kind of thing. So yeah. So now let's get into some general stuff. So, number one, you're going to be nervous, okay? Everyone is nervous. Everyone is terrified, and my school definitely understood that. And so in the spirit of this, once you're done, they give out these little guys right here, and so they get it. Like they know everyone kind of went through this. As soon as your oral argument was over, the judges, they flip a switch and they're really nice and they say, you did great. I know that you're nervous. Here's all the things you did really well. Here's a couple of things that you could work on. And it was great. And your professors are always like really supportive and stuff. And the other thing, you're surrounded by other people who are super nervous as well. You're all students, you're all 1Ls, you're all suffering together, and so that's bringing you closer together. It's really funny to see how people talk right beforehand, because they open up or they clam up, but it's I had a lot of conversations with a lot of people that I had never really talked to yet, because they were so nervous. They needed something. And I've like, when I get nervous, I'm a talker. Like I can't shut up. And so I'm sure I probably annoyed a couple of people with that, but it was fun. It was definitely fun. Another thing which is pretty funny is that so I definitely want to try out for moot court for next year, which is essentially this. It's what I just did. It's what I just described to you. But a lot of people were super nervous and saying, oh no, I don't want to try it for moot court or anything like that. And then right after the oral argument, they say, wow, that was super fun. I think I want to try it for moot court, because it is fun. It's super fun to be, there's nothing better than having an informed debate. Having a situation where two sides present an argument, like two sides are arguing, that's definitely true, but it's the substance of the argument that is fascinating. It's based in reality. It's based on, my brothers have asked me a couple times, how can there be disputes within the law when you're looking at a statute? How can that be? The statute says what it says, and then you're either right or you're wrong. Well, again, that's not necessarily true. There's so many different little things in the statutes. There's so many different little just little things in all these statutes, and the law is super complicated. And so this was not about, the case that I was arguing was not about whether or not the statute says one thing or another. It says that my case was essentially about, does this statute even apply? Does it count? Can someone go and claim discrimination if nothing has really happened to them? What's the bar for saying, yes, you've been discriminated against? The vast majority of cases get dismissed. The vast majority of the cases have a 12b6 motion, and then the court dismisses it, because a lot of times a dismissal is essentially a factual dispute, and so, or no, it's like not a factual dispute, but it's like on the facts, and so it's usually the defendant who files a 12b6 motion, at least in federal court, and says, "Judge, look at these facts. All right, these facts demonstrate that these people do not have a case because the law doesn't support it, or because the statute of limitations is run, or because they're just wrong. They're simply wrong, or the law says something else, and so they're misapplying the law and all that stuff." And although that would be a demur, but it's just saying, given these facts, giving the benefit of the doubt 100% to the plaintiff, this still is not a case. And the vast majority of them do get thrown out. The vast majority of the time, lawsuits they don't go anywhere, because they're really, really complicated. So, yeah. And I guess probably the last thing to do would be, once you go and do your own oral argument, prepare, make sure to practice, because again, you're going to have your 3 lines that you'll have just down cold. That you won't have to look down at your script, you won't have to do anything like that. I personally recommend kind of a mixture of, so my partner last night, she was just excellent, she was so good, but she read a little bit too much from a script, and the judges commented on that last night. I was the exact opposite, and they also commented on that. They said, you're a little too casual, don't be so casual, be a little bit more kind of I guess polished, but not polished. It's more of just slightly more scripted. And so I would definitely suggest that you have 2 pages. On the first page, you have your little spiel, which makes sense, and then you have your 2 or 3 points or whatever, and then underneath that you have 3 or 4 bullet points for each one. So you can kind of really direct the conversation, and then on the second page you just have Like what I did is I had the name of the case and I had like the solid quotes like from each one of those cases. And then occasionally I would look down and like recite it verbatim. I mean, that's what you got to do sometimes. And the judge says, yes, when you're doing that, of course you should look down in order to make sure that you're getting it exactly right. But other than that, it's fun. It's super, super, super fun. And I highly encourage all of you to do it. Of course you're going to be nervous, but don't worry. You'll be just fine. Okay, so let's see here. I think next week, I'm not even sure what we're going to talk about next week, but I think we'll figure it out when we get there. All right? Okay, see you later, guys.